You probably heard about IP-28, or the Peace Act up in Oregon, that effort to outlaw fishing and hunting and everything like that. Well, it didn't get the signatures needed to get on the ballot this year, but this was actually, I think, the 4th time they've tried this, and I think they're going to try it again, so we're not done with this. So, you know, a lot of people, the first thing they think about something like this in Oregon is, well, why not just make a constitutional amendment to make sure something like that never happens? Well, here you go. Here is a proposed constitutional amendment right here. I've got a copy of it. I'll go ahead and read it to you. This was put out by a Senator, David Brock Smith. And this is not an amendment being done right now. It's just proposed. So it needs to go to the vote and go through the whole process. But this is one proposal for an amendment. It says, whereas Oregon residents have a strong interest in sourcing their own food, both wild and foraged, and whereas the self-reliant sourcing of wild foods has been and continues to be a part of Oregon's heritage, and whereas the right to fish, hunt, or harvest wildlife and gather wild foods will not supersede wildlife conservation and management laws and regulations, nor public and private rights. Now, therefore, be it resolved in Legislative Assembly of the State of Oregon. So that's just the introduction. And what that introduction establishes, though, is that what it's trying to say is that Oregonians they like to do this thing. There's a lot of them. It's something that's in the public interest. So that's important, because in any sort of legal proceedings, you have to show that there's an interest. You got to show that there's enough people interested in this to make it a valid point. Okay, so here is Section 48, Article 1, Section 48. Residents of this state have the right to fish, hunt, or harvest wildlife and gather wild foods by traditional methods or manners, subject only to laws enacted by the Legislative Assembly and rules adopted by state agencies to promote sound wildlife conservation and management. The right to fish, hunt, or harvest wildlife and gathered wild foods is a valued part of Oregon's heritage and shall be forever preserved. So there's, again, trying to establish that this is something that a lot of people are into. And that's good. And talks about the need for establishing limits and managing the resources. So that's all good. Now there's one more sentence. This section does not abrogate, which means repeal, annul, nullify, any public or private property rights or the sovereignty of the state over its natural resources. So ultimately, it's the state that has all the power. You might have the right to fish, but the state's going to tell you exactly what that right entails. They're still in ultimate control. So that could possibly lead to some issues down the road. So, in talking to different people about this, there's, the criticism, one criticism that I heard was, this is a document that's been written by politicians for politicians, because it really doesn't address the public's right to fish. It establishes the state's control over the people's right to fish. So a little bit of a nuance there. Now, it might be helpful in thwarting off some future attack on fishing and hunting, but the thing about constitutional amendments, especially in Oregon, they're really good at amending the Constitution. The Oregon State Constitution has been amended 260 times since 1902. It was created in 1857, well, when it became a state in 1859, but it was first written in 1857. So for 45 years or so, there were no amendments at all, but since then, averaging better than 2 a year. So the Constitution can change. So as far as the right to fish goes, it might be best that we not only have good, solid state constitutions, but also have protections at the federal level. Now, the original Oregon State Constitution was written in 1857 while Oregon was still just a territory, and in 1859 it was ratified as it became a state. But 1857, 58, and time, right at that time, the United States was a crazy time. There was all kinds of things going on with lots of expansion. New states were being created. In fact, the Oregon State Constitution is really just a copy of the Nebraska Constitution that had just been ratified just prior. And so Oregon, it took that Constitution from Nebraska and tweaked it to Oregon's needs. And the things that were mostly argued about at that time among the delegates of this Constitutional Convention, there were 60 of them. Most of them were Democrats, most of them were farmers, and quite a few lawyers, but most of them were farmers. And being farmers, being Democrats, they were very much in the states' rights. So the major issues of the time were slavery, alcohol, in Oregon anyway, and where the boundaries were going to be, because this was not long after, threatening to go to war with Great Britain over southwestern British Columbia, where that northern line was going to be. So, and you had Washington still as a territory, and so there was arguments about exactly what we meant by the state of Oregon still at that time. But the biggest issue was slavery. Now, there was a man named Matthew Deedy. He was the president of the convention. He was a very important politician back in those days. He was actually a blacksmith, I think, turned lawyer, eventually became a federal judge. And there's a Deedy Hall in the University of Oregon named after him. Now Deedy, which is kind of normal at the time, was extremely racist, and he was a big supporter of the Dred Scott decision. So it's a Supreme Court decision that basically said that freed slaves could not become citizens. So in the Oregon State Constitution, it was written in there that freed slaves, or just black people, or I think include Chinese and mulattoes and just people of color, were not going to be eligible to be citizens. And at the same time, though, they did outlaw slavery in Oregon. Oregon was not ever a slave state. Now, another big issue at the time was liquor. The Oregon Territory had actually outlawed liquor in the previous decade. And that had to do with an old man named William Johnson out in the Willamette Valley, who had a still, and he made something called Blue Ruin. And I guess it ruined some people because it caused a lot of problems. Maybe not outlawed drinking. What they did is there were big fines for importing, for making it. You couldn't have a still or anything, and for selling it. But there was really no consequence for drinking it, which I thought was kind of odd. And also, if you were a doctor, you were given the opportunity to distribute a gallon at a time of medicine. So the doctors, I think, probably had pretty good business back then. I don't know. But when it all came down to it, they just ignored that completely in the original Constitution. So liquor was not outlawed to begin with when Oregon became a state, much to the distress of the missionary party, or the missionaries. They were Methodists, I think, that were no fun to party with, but they were very strong politically, and I'm sure they're the ones that were fighting the liquor thing for the most part. And then the boundaries of the state, that was eventually resolved, and Oregon became state. And that Constitution stayed stable, unchanged for 45 years or so, till 1902. And since then, like I said earlier, lots and lots of amendments. So just because an amendment like Senate Joint Resolution 13 is created, that doesn't mean it can't be changed in the future, because Oregon's done 260 changes to the Constitution in the last 120 something years. So it'll be interesting to see what happens with this proposal or any other proposal for a amendment to the Constitution. It has to go to the vote to the people. And what'll be really interesting is to see who opposes it, whether it's badly written or not. Who opposes a constitutional amendment that attempts to give the people the right to fish? So that's what we've got to pay attention to.